Yes, sir. Good afternoon, everyone.
Good afternoon. Good afternoon, Justice Anand. Good afternoon, everybody.
Yeah. I, on behalf of Beyond Law-CLC, welcome you all. As we all know that we are in the stages of unlocking, but during these testing times, we have been trying to enhance our knowledge through the speakers who have immense knowledge in various perspectives of law and beyond law, as our topic suggests. In this endeavor and pursuit to connect on this platform, we have been always trying to connect with the persons who can give us the insights and the nitty-gritties of all aspects on which he specializes. And today I'm more happy on that aspect. It's a rare occasion that on a platform, we had once the wife coming and giving the inputs, and today Justice Roshan Dalvi's husband, who is a renowned professor in the field of drafting, is giving us the insights. And we thought that we had done a lot of knowledge on the basic laws. But at the same time, we realized that, as they say, the building stands only if the basic structure is good. And any time, even if you are in the law or the litigation, it all ultimately is correlated with the pleadings and draftings. On this issue, we requested Mr. Shamim Dalvi, advocate and a visiting faculty, adjunct professor in Bombay Law University. He has been teaching for last 34 years out there. And we all know that the standard of lawyers and volume of teaching skills being culled out from Bombay Law University. So much so, we all, as we had shared yesterday, Dalvi has drafted the commercial laws for the government of Bhutan, and he had been the advisor to the Office of Legal Affairs of Bhutan. He also played, he was instrumentality in the framing of the Constitution of Bhutan. During the course of the webinar, we will ask what is the subtle differences between the Constitution and the commercial law of Bhutan as such. From his knowledge, we would like to gain from that. We are all pleased that our webinars have been well received. Amongst us, we also have, needless to say, Justice Roshan Dalvi, former judge of the Bombay High Court. Mr. Dalvi is quite ecstatic about the fact that ma'am is listening as a participant this time. And it's a good occasion where the husband and wife are speaking on a knowledge sharing platform. Amongst us, also we have former judge of Punjab Haryana High Court, Justice S.D. Anand. Those who have been connected with us on the previous occasions, they know that Justice S.D. Anand has been kind enough to give his insights on the topic of death penalty. And even otherwise, he has been coming on our platform as a participant, but not only as a participant, but as an active inputs he has been giving different times. He has also written books. Without taking much time, I would request Mr. Shamim Dalvi to give us the insights, because yesterday, while we were discussing the topic, the only aspect I said that, sir, I have always believed that before making the opening statement, if the pleadings are good or the drafting is good, it makes the half battle won. And therefore, we requested him, and he was kind enough to give an accent, not yesterday, but a few days ago. Thank you, sir. We are all enamored by the fact that you have joined us on this platform. Thank you.
Thank you so much for the intro, and thanks, everybody. The first question that arises is, why drafting? Maybe I'm not familiar with the statutes of this country. That is a lighter vein, I would like to say that. But to me, drafting is the crux of everything. If you're not good in drafting, if your drafting is poor, it takes you nowhere. So the question is, how would you compare drafting with the substantive laws of the country? The difference between the two is this. Substantive laws can be read and understood, but drafting is a different ballgame altogether. To me, drafting is the sine qua non of the legal practice. And therefore, what is important is this, that this is a subject which has to be cultivated over time, and it's only then that you get a hang of it. I will begin with a very important aspect of this as to what happens if your drafting is bad or poor. And I take you back to 1981 when I was a rookie. And although I was in law firm, and I was doing drafting and specializing in documentation, a partner of the firm asked me to help him in a litigation because his junior was absconding. And therefore, I readily agreed to help him. We went to the court, the Bombay City Civil Court, and the judge told us that he will take up the matter at 3 o'clock in the afternoon. When we went there at 3 o'clock, the judge said that he will take this matter on a day-to-day basis. So I was quite surprised. Mind you, this matter was on an ad interim application of a draft notice of motion. It was not even an interim application. The matter went on for 15 days, at the end of which the judge turned out a 172-page order. Mind you, on an ad interim application, the order was of 172 page. My firm's client won, the other side went in appeal, and the appeal came before Justice S.K. Desai, who to my mind was amongst the most brilliant judges in the country. Justice S.K. Desai told the appellant's lawyer, what is there in these 172 pages except the first sentence? And the first sentence was, and I quote, this is an unfortunate dispute between two sporting associations. Justice Desai threw down the papers, he said appeal dismissed, and the matter was over. What happened later was this. The judge who gave this 172-page order on an appeal from order was transferred summarily to the Judicial Academy at Nagpur called Jyoti. And he was so frustrated, for whatever reason, that he unfortunately died in harness in that academy. So what I would like to know is this, like you to know is this, that you write 102 pages and you seal your fate, you seal your career, and also seal your life. That is what happens when you write page after page. Now, what is important is this. Drafting is a very peculiar aspect because it is directly connected with the brain power or the thinking power of the person who drafts. Lord Denning, in his Discipline of Law, has said that words are the vehicle of thought. So therefore, he links language to thinking. And he says, words are the tool of trade of a lawyer's trade. If that is so, let us see what exactly we mean by that. Lord Denning further said that obscurity in thinking leads to obscurity in language. Lord Denning has further adverted to Sir George Jessel, who said, and I quote, I may be wrong, but I am never in doubt. What do we exactly mean by all these three things? First, the thought process. It means this, that drafting is directly correlated to the thought process or the thinking of the person, the draftsman. Second, what is important is this. The hallmark or the core issue of the drafting is clarity. Apart from the fact that there has to be certainty, clarity is the most important thing. If there is no clarity, if there is no confusion, if there is confusion, if there is garbled drafting, then neither the other side nor the judge will understand what is written. So therefore, what is important is this, that when there has to be certainty, the more important thing is clarity, because it is clarity that has to come first, along with certainty. Because in the guise of making something certain, and if you don't have clarity, then there will be obscurity. It is here that I would like to demonstrate the principles of drafting. And may I have the
screen sharing will be done. Devika, yeah. Kindly do the screen sharing.
Right, yeah, the screen sharing, please.
Yes, sir. We have started it.
Yes. Yeah. First, how do I do it?
Devika, second page. Yes.
Yeah. thought process, the quality of drafting reflects the thinking power which can be cultivated and refined. Language is an effective tool of communication. Cluttered or confused thinking results in muddled, unintelligible, ambiguous drafting. Now, what are the essentials of drafting? Clear thinking, command over the language, clarity in the language, precision and conciseness, no ambiguity, and no repetition. What is important is this. The clear thinking has to be reflected in the language that you produce. You must have a sizable command over the language which you profess. Then the language has to be clear, which I said already, that is correlated to the thinking. There has to be precision, means the language has to be precise. There has to be conciseness. It has to be brief. There has to be brevity. And there has to be no ambiguity and no repetition. Now, here you will see two things. What is positive, what is negative. Positive is clear, unambiguous, definite, conclusive, coherent, precise, concise. What is not required and what is not wanted absolutely is must not give rise to multiple interpretations, must not be verbose, must not be tautology, must not be repetitive, there must be no confusion. There has to be no lengthy language, and the language has to be devoid by superfluous words. Now, here, what is important is this. Essential characteristics of drafting. The three essential characteristics of drafting are law, facts, and language. Drafting is nothing but the synthesis of law and facts in the form of language. Law is the foundation, facts are the structure, and the language is the architecture. Now, how would you go about drafting, whether it is a document, whether it is a pleading? First, master the facts. Ascertain the applicable law. Marshal your thoughts. Arrange the thoughts chronologically in your mind from the past to the present. Conceive a plan or design of the draft that you're going to put out. Nothing relevant should be omitted or admitted at random. A necessary result should not be stated or overstated. The format must be logical. Language must be precise, accurate, unambiguous, capable of clear meaning and not multiple interpretation. Avoid repetition. Use the familiar word to the far-fetched word, the concrete and the definite word to the abstract word, the single word to the circumlocution word. Yeah, no, that's good. That's it. Yeah.
Now come back.
Yeah. Yeah, that is over now. Hello. Yeah. Now we go back to the presentation, please. Please take out the screen share.
Devika, stop the screen sharing.
Okay.
Yes, sir.
Yes. Yeah.
Done that, sir.
Yes.
Yes.
Yeah. Hello. Yes.
Yes, sir. It's all.
Yeah. Yeah. Now, a well-drafted or well-crafted document is elegant in every way. Why? Because it is clear, it is unambiguous, it is thoughtful, it is cohesive, it is precise and concise. This obviously presupposes that the draftsman must have analytical skills, knowledge of law, and a discerning eye for details to make subtle variations in the language, which we call nuances. Now, therefore, what are the ingredients of a good draft? Aside from what I have already told you, simplicity, clarity, precision, and conciseness. The draft must advance the client's goal and reduce the risk which to his otherwise would be exposed. Avoid ambiguity, provide sufficient space to each party, make provisions for conclusion, breach, and remedies, and most importantly, ensure that there are no loopholes and there are no loopholes so that the litigation can be prevented. Use short sentences and avoid words which can lead to multiple interpretations. Now, striking a personal note, I would like to say this. I am a firm believer in preventive litigation than creative litigation. If your documentation, if your drafting is clean, clear, without loopholes, you don't have to go and litigate. Of course, litigators will not like my philosophy, but that is a fact. That if your drafting is clean, if your drafting is without loophole, you don't have to knock on the doors of the court. And that is how it is. Of course, litigators and document drafters differ, that litigators are out to win at all cost. Mutual cooperation is not in their Gita or Bible. And draftsmen are competitive, but in a cooperative venture. Now, the question that arises is, must litigators learn how to draft? Undoubtedly, yes. Because in any case of the matter, unless they know how to draft, they will not know how to advance arguments in a court of law. And that is how it is. Even when to interpret and analyze documents and settlement in a court, they obviously need to have knowledge of drafting. Now, talking of litigation and litigators, I would like to say this. How many of lawyers observe the provisions of Order 7 and Order 19 of the Code of Civil Procedure? I must confess that I had not opened the Civil Procedure Code ever since I passed law in 1976. It is for the first time last week that I opened and saw the index and took out two words, namely plaint and affidavits. Now, here I saw that in Order 7 spells out categorically that a plaint must contain facts constituting the cause of action and when the cause of action arose. How many lawyers do that? Most of the plaints are full of judgments, passages from citations, authorities, and they don't have a regard for what Order 7 says. Order 19 relates to affidavits. What does it say? It says inter alia that affidavits shall be confined to such facts as the deponents are able to prove of his own knowledge. Rule 3 of Order 19 says that the cost of the affidavit, which shall unnecessarily set forth matters of hearsay and arguments, shall be paid by the party filing the same. The million-dollar question, therefore, is how many lawyers adhere to those two orders and how many judges impose costs? Chief Justice N.C. Chagla, the first Indian Chief Justice of the Bombay High Court, in his Roses in December, has categorically stated, and I quote, that I never ever read pleadings before going to the court throughout my judicial career. We don't have to go far to find out why he did not read pleadings. And there are many judges, to my own knowledge, who never read pleadings for what obvious reasons. Because the pleadings are verbose, unreadable, and many advert to passages from judgments as their own in the fond hope of augmenting their client's cause. Does this help? Answer is absolutely no. So now I would like to just go through what we will require to do as far as drafting a good draft is concerned. Which we have already said, command over the language, clarity, precision, conciseness, no ambiguity, repetition, and all that. Now I would like to come to some specifics. When a lawyer drafts a will, he has to be more careful or more than careful in order to ensure that the will is absolutely clear, the language is clear, and it is absolutely precise and succinct. It is definite and exact. In a will, a lawyer must take care to ensure that you must never overstate or overstate your case. And I will illustrate this by a case which has gone right up to the Supreme Court from the Bombay High Court. A man had two sons, one living in Calcutta and the other in Bombay. The man and the Calcutta son stayed together, and the Bombay son stayed in Bombay. The man was extremely rich. He owned 12 buildings with 15 to 20 flats in each building. He owned five businesses across the country, and he owned a big bungalow in Bombay, in a place called Andheri in Bombay. Now, when his son in Calcutta had to go to United Kingdom for a holiday, he requested the Bombay son to look after the father for 3 months, at the end of which he would take the father back to Calcutta. It so happened that when the father came to Calcutta, the Bombay son drafted his father's will. He went to a large law firm and instructed the lawyer to draft his father's will. Now, see what the will contained. The will stated again and over pages that the Calcutta son humiliated the testator, did not take care of him, did not look after him, and therefore he is giving the entire estate to the Bombay son. The will went on to say repeatedly with verbosity that the Bombay son in 3 months looked after him so well, his children, his grandchildren, that he is so pleased with the Bombay son that he is giving entire estate to the Bombay son. Caveat was filed. The matter came before the trial judge in the Bombay High Court and then the division bench, and eventually went to the Supreme Court. The crux of the matter was the will genuine? Now, I ask you all a question, that a man who is so rich, a man who owns 12 buildings, 5 businesses, a bungalow in Bombay, why would he suffer the indignities and the humiliation at the hands of the Calcutta son with all the money that he had? And in fact, the house where he stayed was not the son's house. It was his own house. And he could have kicked out the son and told him to get lost. Or he could have gone and stayed in any of the flats which he owned in Calcutta, requested his daughters which he had, and told him to come and cook for him, or appointed maids for him and servants for him. A man who stayed in Calcutta for 84 years with his Calcutta son came to Bombay for 3 months, and the Bombay son made his will to the effect that he has been ill-treated by the Calcutta son. The crux of the matter was this: would he care to stay with that son if he was really humiliated and insulted and ill-kept and not looked after? And that was the matter which appealed to the trial judge, the division bench of the Bombay High Court, and the Supreme Court. What I would therefore require you to understand is this: never ever overstate the case in a will. Be simple, be clear, and be short. Overstating the case does not make the will strong. Even the wrong advice which lawyers give, that wills should be registered, does not make the will any better. Now let us take the case of lease and legal license. Section 105 of the Transfer of Property Act defines a lease as a transfer of interest. An interest of the owner is transferred by a document, an agreement to lease, or the deed of lease. As far as the legal license is concerned, the Easements Act and the Bombay Rent Act have adverted to the legal license. And the difference between the two, lease and the legal license, is absolutely this: that in a legal license, what is allowed to the licensee is a mere permission to use the premises, and he does not have any interest transferred in his or her favor. And that is the distinction that has happened. It so happened once again in the Bombay case, which has again gone to the Supreme Court, but it was not my case, someone else's case, where a person who excelled in a different branch of law was asked to prepare a deed of lease, which he did not know anything about, although he was a very senior solicitor. And instead of deed of lease, a legal license agreement was drafted. It was an American corporation, which was a licensee, which was supposed to be a lessee, which became by back drafting as a licensee. And eventually, ultimately, the matter went to the court, and the licensee, when they occupied the premises, were evicted summarily because what they had in their hand was not a lease, but a license. So that is how it is in this case. Finally, it is needless to remind you that a lawyer is a student all his life and continues to be a student, and continuing legal education is a necessity. I will cite a case which has nothing to do with drafting, but nonetheless on something like of seeing the law. A client went to a lawyer in Bombay and requested him to file a winding up petition under the old act, under the 1956 statute. And sections 433 and 434 of the Companies Act have an inbuilt provision as to where the statutory notice has to be served. The section says it very clearly. Unfortunately, this lawyer did not open the Companies Act, and he sent a notice to the factory, which was at Nasik. The registered office of the company was at Worli, Bombay, where he should have sent a registered notice, the statutory notice. But he sent the notice, the statutory notice, instead to Nasik. And the matter came before Justice D.R. Dhanuka, who was then the judge of the Bombay High Court. And in those days, the matter would come up for acceptance first and then admission. He threw the papers down because the basic necessity, the requirement that notice had to be sent at the registered office of the company was not followed. So what is important is every lawyer is a student of law, right, until he or she dies. And therefore, he or she must open the book whenever he has to do some work. Now, what I would like to advert you to the age-old concept of the Narada Smriti. In those days when there was no documentation, when there was no conveyancing, when there was no deed of conveyance, or a deed of lease, or a deed of gift, what does the Narada Smriti say? And I quote, this has been quoted by Mr. G.M. Divekar in his book on deeds. And I quote, writing is an excellent eye, EYE, as it solves all doubts which would otherwise arise. Aspects which we are likely to forget and see through can be seen by creating a written document. And that is what is important about drafting, and that is what it is. But drafting does not have to be like, as I said, the language is the architecture. But the architecture does not have to be a confused architecture. It does not have to be Gothic or Victorian or anything. It has to be simple, simple, and simple. And therefore, it does not have to be like modern art, which most of us don't understand. It has to be simple and simple. It is said that you must practice what you preach. And I have preached that whatever you draft has to be precise, concise, and brief. And therefore, if I have preached that, I can't go on talking verbosely. And therefore, I would like to conclude here and invite questions, if any. Thank you. Yes? Nothing is coming.
Yes, sir.
Yes.
So the insights, which
Yes.
when we had
Yes. Yes.
started the
I have
webinar,
seen that. I have. I will take you back to my rookie days, and my senior in my law firm where I was practicing, where I was interning, he was very fond of our counsel. And we used to take a big ride to the suburbs of Bombay and have conferences with him. So one day, this lawyer counsel told me that you come to my house in a place called Thar and I will dictate the petition. He used to specialize in customs and excise. To my horror, I found that in the petition, he was citing passage after passage from judgments by different high courts and the Supreme Court. On the next Monday, when my senior asked me what happened, I said, this is what the counsel was doing. So he patted me on the back and he told me, you have yet to learn how to make money. So the answer I have to give you to this question is, you must never cite judgments in pleadings. Never do that. Because as I said, I read out order 7 and the order says facts. That's it. So if the order 7 of the CPC says facts, you have to only mention facts so as to buttress the fact as to how the cause of action has arisen. That's all. And to say, of course, as the order says, when, at which point of time the cause of action arose. That's it.
thank you, sir. Uh, this was by 1+7. Both this thing. Two questions have come. Both have said that some citations should also be included in the pleadings. Drafting of pleadings should be limited or up to how many pages? What is your crux? How do you? I ask a question since that question has not come, because invariably we write that the questions can be posted at 4:45. The participants were mentally prepared on that way. But be that as it may, since we are also into the law, I would just like to ask, how should one structure? Let's assume it's a civil suit or a complaint or a writ petition. How should he structure within the mind so that he should draft? Whether he should read the entire petition before starting the dictation, or he should start reading the pages and continue to draft, or should he ask the client to sit across and keep on pouring the facts as such? What is your call?
No, the first thing is that you must study the facts, master the facts, and you must confine yourself only to the facts and never ever revert to this. See, in a writ petition, as those who draft writ petition, they will tell you that you have to cite the grounds on which you're filing the writ petition. But in a plain, you don't have to cite the grounds on which you're filing the plaint. So, so that is how it is. And as I said, the drafting should be such that from the past to the present. That means you must start the facts from the past, come to the present, and strike at where the cause of action has arisen. That's how it has to be. You don't have to as Justice Chagla said, everything depends on how the arguments are advanced by both sides. You don't have to go into the pleadings at all.
So another question would be, let's assume somebody has lost a suit. Ultimately, out of two, both can't win. It's not mediation or an ODR. In that eventuality, what should one do while taking the grounds of appeal? What should be the take for while drafting the grounds of appeal?
A lawyer always has the option of filing documents by way of what we call compilations. So that can be done on which the arbitrator or something can place reliance on. You don't have to go on multiplying the pleadings by this when the civil procedure code, which is the Bible of the code, when it says that you have to do only facts, you must confine yourself to facts. And other things have to be done by way of the annexures. And that is how it is.
So this question is by Pavan. He says that while drafting a lease deed, some firms are drafting the lease deed into 100 pages. What is important? What do you think that it should be kept in mind while drafting the lease deed, or for that matter, any agreement?
I will tell you this. First of all, let us go to 100 pages. And where does this disease start? The disease starts at the student level. I have got many students who feel that if they write 100 pages in the university exam, they will at least get 70, 80 marks. So therefore, they feel that the marks are commensurate with the number of pages which are written on a university exam. So the disease starts from the student days, which should be ebbed. Now, coming back to a lease, the crux of the matter in a lease, or for that matter, a deed of sale or a deed of mortgage, is the title. And therefore, the question is this: every deed has to be divided into two portions. One is the recitals, and the second is the operative portion. In the recitals, you recite the title to of the property from the past to the present. You go from the past and you come to the present, and you come to the stage as to how the present owner is the owner or claiming to be the owner and claiming title to the property. So the question in a property transaction is the title, the interest, the legal interest. So therefore, what is important is that you have to write, you have to convince the lessee that the lessor or the owner has got title of ownership to the property, and that has to be done in the recitals. When you come to the operative portion, obviously, every deed of sale or lease or mortgage has got a very important component, which is called the covenants. Now, the covenants are what is called promises which are made on oath or as if they are made on oath. And the person who is giving a covenant, if it is proved to be false, can be held for perjury. So therefore, the covenants will follow. You don't have to. There are certain basic. You see, the documents is like this. Most of the documents are packed with legalese. That means legal jargon. Now, what happens is this: the Victorian English and the American English. There's always a conflict between the two. And if you go to the Victorian English, you go to the Victorian type of drafting, and that is how it is full of legalese. The American English is is a cutout English. And today we have reached a stage right from 1980s onwards of what is called plain English. And the plain English is really good. And that is how. So even then, the same covenant, which is full of legalese, the covenant of title, the covenant of encumbrance, against encumbrance, the covenant of giving documents at a later stage. All these covenants can be written in simple English, and that is how it is. Now, coming to this question is this. Two things are important. One is this. When we were studying or when we were in law firms, we never had the density. Even today, I don't know how to press a computer button and use the internet. But the fact of the matter is, today's students are told by the seniors to press the computer button, copy. In fact, I'm sorry, I did not refer to one important thing. No lawyer worth his salt must ever copy from precedent or do a cut and paste job from a precedent. That can totally mar the whole project. In fact, the case which I referred to about lease and the legal license agreement was done exactly like that. The junior who did that in that firm, he took out from the precedent a legal license agreement, and instead of a deed of lease, he dished out what is called a legal license agreement. So therefore, what is important is this, that clients such as banks or corporates, they feel that if you produce a heavy document, you can charge 30 lakhs, 40 lakhs in fees. And that is how lawyers are told to make the document as bulky as possible. And if you really see this, the document is not bulky. The document is full of annexures, and that is what makes the document bulky. And that is what makes the law firm charge heavy fees.
This question is, while drafting an agreement, I'm slightly refining the question, which I feel that it will cover every aspect. Mr. Mishra says, what is the difference between lease license, and the tenancy agreement? And I go a step further. What one should keep in mind while drafting these three issues?
In In the amended Rent Act, you see the tenancy agreement. First of all, tenancy was never done via documents. It was what is called in Hindi pagri system. But today you can have an agreement, a tenancy agreement under the amended Rent Act. That is how it is. Now, basically, there is a very thin dividing line between a lease and a tenancy. Now, what are the components of a lease? The components of a lease are that the lease has to be for a fixed period, there has to be a premium, and the lease rent, and that is how it is. A lease can also be in perpetuity, which is an oxymoron because perpetuity means unlimited. So therefore, that is how it is. A lease has to be registered. A lease must be executed by the lessor and the lessee and must be attested. These are the legal requirements. And that's how it is.
So, since we have been discussing of pleadings, Mizan Patel has asked, generally it is said that drafting of written statement is difficult, maybe because the defendant wants to keep some facts concealed and wants to tread cautiously. What are your tips on drafting of the written statement?
A written statement obviously has to be drafted in juxtaposition to the plaint. And therefore, what is important is under the amendment now, if you are denying something, if you're doing something, then you must if you're denying something, you must set out in the written statement the reason why you're doing it. The reason why you're doing it. And that reason has to be not a conceived reason. It must be the real reason as to why you're doing it. A written statement obviously is filed in juxtaposition to the plaint, and that is how it has to be. And therefore, obviously, there also you can't cite pleadings. You can't cite judgments. It has to be facts, but it has to be obviously. It'll obviously a written statement can be bulky because it has to advert to the various points taken in the plaint.
What is your take? Let's assume a written statement is to be prepared. One should give the brief background because some lawyers and some firms, while drafting it, writes preliminary objections, some brief background, and then they cover the written statement point-wise, para-wise. So what is your take? How should one draft the preliminary objections and a brief background while drafting a written statement?
Personally, I would like to do this. That if there are certain issues which need to be highlighted so that the court understands them before we go to the clauses, then we must make an omnibus paragraph where you must take up these points which are very relevant and then go to para-wise rebuttal. There is nothing wrong if you do something to say that the true facts as emanating in this matter are as follows, and do that, and then go to para-wise.
In preliminary objection,
your case is put out properly and nicely, and then you go to para-wise. And in that case, which you do in the first para, it must bring out what you feel is the truth.
So this is, does leave and license create third-party rights in the property if the court injuncts the party to create third-party rights in the property?
A leave and license, the licensee has, unlike a lessee, has no right to create any rights because the property is not his or hers. In a lease, the lessee has a right to create third-party rights, undoubtedly, because the interest is transferred in his favor. And therefore, there is hardly any difference between a sale and a lease. Because what is the difference? The difference is this, that in a lease, the lessor, the owner, retains with him a slight interest in the property and transfers the right to enjoy and use and occupy the premises or the property to the lessee. In a license, that is never done because the license is mere permission to use, and the licensee has no right because he obviously to sublease or sublicense. Sublicense because he has no right in himself. So therefore, there's no question of giving anything. What you don't possess, you can't give.
So the next question, taking cue from what you had suggested that judgment shouldn't be referred. One of the questions, though he has posted it privately to me in the chat box, he says that you are saying that the judgment should not be referred in the part of the pleadings. But in case the judgments have been cited and the judge doesn't refer, then how will you build up your case in an appeal? Because the judge may say that you did not take this point or you did not show this judgment. So what is your call? To this, we will, since we have unmuted Justice S.D. Anand and Justice Roshan Dalvi also, we will take their insights also.
Yeah, the answer to this question is this. What are lawyers for? When they stand in before the court, before the judge, they have to argue. Now the question is, judgments can never be a part of the plaint, and no judge can say that you have not referred to it, because what you have to refer is only what is germane to the cause of action. The citations are not germane to the cause of action, and therefore there is no question of any judgment. And then what you can do is this. There are two ways of doing it. One, you submit orally across the bench a compilation of the judgments you're relying on, or along with the plaint, you file a separate compilation. But you can't do that in a plaint, and the judge and the court will be wrong in saying that you have not relied upon this. You have to rely upon it while arguing. What are you doing in the court then, if you're not arguing and relying upon judgments?
In fact, we had one of the judges out here, Justice Rajiv Rana, is just superannuated. His style was, whenever you used to give the judgments, he would say, while issuing a notice motion, a compendium of the judgments is given, registry is directed to attach these judgments at the back of the file, so that it becomes the part of that.
Yeah,
Justice Roshan Dalvi is nodding the head. We will ask her take also. What is her call? How the lawyer should go about?
Yes,
Yes,
but
ma'am. What is your call?
Yeah, it cannot form part
of
the
now, since sir has given the session, now we are keeping this an open session when Justice Roshan Dalvi and Justice S.D. Anand log with you would give the insights on different perspectives so that people come to know as a lawyer and as a judge what should be done. So, ma'am, what is your call?
No, I was only telling you that what the judge did was correct. It could not be a part of the plaint, but it had to be considered. And therefore the judge said, okay, amended. You annex it to the plaint, I will read it. I also used to call for judgments, but that doesn't mean they become pleadings. Two nice things I wanted to tell you. One is,
Pardon?
two very good examples I wanted to give on this.
Yes, ma'am.
The very first plaint in India is the plaint which was filed in the Madras High Court, because that was the first chartered High Court in India under the letters patent. And that plaint consisted of one sentence of 6 lines followed by one prayer, which was on one page of the plaint. It was a case of a price of goods sold and delivered, and the plaintiff only said that I had sent so many goods at this rate of this quality to the defendant, which has not been paid, and for which I have filed this good for price of goods sold and delivered. And then is the prayer that I be granted this as price of goods sold and delivered. Now this plaint, which was by way of a manuscript, is in the museum of Madras High Court. In case you ever go there, it's a lovely thing to see in their museum. So this is how we began, just one page. And we had one very smart judge who used to be very witty. In one matter, which was of a big, large attorney's firm, the plaint was of some 450 pages. They could not tie all those pages together, and they tied it in 2 separate parts. So part 1 and part 2, about 225 pages each. Both the compilations were kept on the desk of the judge. And the judge kept on telling all the parties, I don't see any plaint. Where is the plaint? So the officer went on showing the judge that, my lord, this is the plaint. This is the plaint. He says, no, this is not the plaint. A plaint has to be precise, concise, and brief. This is 450 pages. This is not a plaint. So I will go on the footing that there is no plaint filed. I can't give you any relief. And then the lawyer has to say that no, you look at only this page and you look at only that paragraph and please give us the relief, which of course I think was refused. But he just refused to see it. He's saying this is not the plain. I'm not going to read all this. But now this was just a joke. I mean, it went on up to a point. But in about 1996, when we had Chief Justice M.P. Shah, and he was very horrified to see that in Bombay the pleadings are so bulky and verbose that he instituted this new kind of rule of filing a synopsis. We started having this by about 1997 or so, that every plaint, every petition had to be accompanied by a synopsis. And then obviously the judges would read the synopsis and forget the plaint. Then the synopsis started getting so verbose that then we said that now you give us only a chronology of events and dates. And we read the chronology of events and dates.
In fact, ma'am, what you are suggesting, probably from that only, when we had the Chief Justice S.P. Kurdukar out in Punjab Haryana High Court also, then the concept of list of dates and events came into being.
Yeah.
Because when he came, he introduced the concept that whenever the petitions are to be drafted, and what you said right now, I'm also reminded that there was one petition in the High Court. The list of events constituted of 42 pages. So the directions were issued that the registry is to list the case when there is a synopsis of the synopsis. So this is by Vishnu Kalde. How to draft a legal notice, how to draft medical contracts, and how to draft bail applications and writ petitions. What are the subtle differences between the two, or between all these four?
I am not a criminal lawyer, nor am I a litigator. So the last question I'm not going to deal with.
How to draft a legal notice and medical contracts.
Yes. Even the legal notice, also you must, the same principle applies. You have to be brief. You have to go to the cause of action. And you have to state as to how the cause of action has arisen and how the case of this notice has come about. That's all. You don't have to go page after page and go on reading, because nobody has time and the patience to read pages, whether that is a judge, whether it's the lawyer, whether it's the other side. And I wouldn't read if I received 20 pages at all as a notice. So therefore, the legal notice has to be short. It has to be precise. It has to be consistent. It has to set up the relationship between the parties. And when you set up the relationship between the parties, then you have to say why, what has happened in the briefest if possible. Because if you go on writing pages, nothing is going to happen. Now, when you talk of a medical contract, obviously, I don't know what exactly the questioner means by medical contract. What exactly he wants to know in a medical contract?
It could be, I take a step forward. Let's assume it's a medical insurance contract itself, wherein nowadays, of late, we have been seeing the courts holding that the font used in the contract is so small that one couldn't gauge it. So, and all these agreements are also running into hundreds of pages. Let's assume even if it's in a bigger font, I don't think anybody will read it, except for posting the signatures on the same. So don't you believe that all such contracts should be very concise, like what ma'am said, they should be concise, precise, and incise?
Absolutely. All contracts have to be, first of all, it has to be in plain English, simple English. It has to be precise, and it has to be, precision means definiteness. There has to be definiteness. Concise means it has to be short, brief. Brevity and concise is one and the same. Precision means absolutely definite, exact. It must have exactness. And that is how it is. All contracts have to be like that, whether they're insurance contract, marine contract, anything. It has to be very, very simple and to the point. Because you see, ultimately, you can't have a document which is running into pages and creating what I would call a sea of verbiage. sea of verbiage. It's nothing but all verbiage, verbosity. And ultimately, you don't understand what is written. You don't understand the head or tail of it. And neither the judge nor the other side understand the same thing. So it has to be very, very simple.
So we have, yes, sir. Fortunately enough, we have Justice S.G. Anand, and since he had the roster of criminal law, We will ask him what is his take while drafting the bail petitions and the civil revision, etc.
Yeah.
Yes, sir.
Can you hear me?
Yes, sir. Yes,
Yes.
sir.
You see, so far as the bail applications are concerned, I'll quote an example which will say it all. I'm in the know of a particular matter where right from the word go, the accused said, please get my DNA profiling conducted. It was a great case. But did not make a mention of section 53A in the CRPC in the bill application. It was ignored. It came to be ignored even on merits by the trial court, High Court, and elsewhere also. Whatever plea you have to take, you must make up your mind, because if a plea is required to be taken up in the first instance, there might well be cases in which you can build up a plea later on. In case you are pleading alibi, in case you are pleading private defense, do make a reference with the required brevity, of course, as Mr. Dalvi said, in the first bail application itself. To my mind, the adjudication of a criminal trial, in case such like eventualities are to be pleaded, would depend upon what plea you put up in the first bail application.
We will ask, yes, sir. We will also ask Ma'am Roshan Dalvi to give her insights, because while as a judge, what is her take that while drafting the civil revision on what difference should be there while drafting the civil revision or an RSA at the first instance?
No, so far as the first instance is concerned, a very clear thing which Justice Anand said was right. The first page gives you out. It's like an examination paper where we tell the students, put your best foot forward, write the best answer first. And in the answer, on the first page, write the main thing. So whatever is the best fact, whatever is the best document should be sort of, just given a first look. It makes a very strange sort of impact on the mind of the reader. We had one matter where we were for the defendants, and it was a matter of a school, and there was nothing much in the case. So our defense was threefold or something like that, that time when I was a lawyer about 33 years ago. And we said that we must not say anything. Let the plaintiff say whatever he wants to say, because he'll make his case worse and worse by saying more. And then when our turn came, we said those three things. The notice of motion was dismissed. When he went in the Supreme Court, I only told them in one page, just exactly one page, just set out these three defenses and put it along with the papers if you can. That attorney's firm had a firm in Delhi also. So when that petition was filed and the SLP was filed, they put up those 3 points. And the SLP was summarily dismissed. We were not called upon to argue also. I don't know if the judges read only that one page, because it contained everything that you wanted to say.
So, ma'am, what is your take that, let's assume it's a revision and an RSA, that is regular second appeal. What should one do while drafting? What points should he consider in the mind?
No, I won't be able to say exactly the regular civil appeal or anything like that. The second appeal is a question of law. So you have to draft that question of law. So of course, you have to take up all the grounds in appeal that you cannot miss out really, because that gives you the points to argue also, without of course any repetition. One other thing on the side that I might want to say is, when you ask about notices, how they could be drafted, yes, you say the facts and you demand whatever you want in a notice. But now we say, and that is consequent to my lecture which I gave last time, that when you give the notice itself, by and large, if you are a bona fide litigant and want to get something out of it, but not waste the time of somebody else, you make an offer of mediation in the notice itself. That, I am entitled to this, I would be doing this, you demand whatever you want. However, in the last or the penultimate paragraph, if you want, we can meet and we can settle this. And if lawyers can start doing that while client counseling, and if lawyers come together, I tell you, the image of the lawyers will really increase in the minds of the litigants. Because you will be semi-judges. You can come together, sit together, as I said in that ADR presentation of mine, client, lawyer, all coming and sitting together. That would be pursuant to a notice. And that notice itself must not demand, but request and appeal for mediation.
We will ask Justice Anand that, since he has seen on the other side, what is his take that how should one draft the written civil revision or an RSA?
I think the first thing, allow me to say at the very outset, is to very carefully read the pleadings of the parties and the findings recorded by the courts. That's, why I say so. I'm in the know of a matter, specific performance matter, where there was complete want of evidence to prove that the gentleman who had to pay up was possessed of funds much less adequate on the day the amount was to be paid for the purpose of registration. You must be able to call out what were the law points, whether those law points were attended. Even on facts, it could be a mixed question of law and fact. You will almost in every case find that there is something which you can make out in the form of law. Even though, of course, the frame of a statutory question of law is not a mandate now. And then you can focus upon it. But then brevity is suffering a lot of fatality, as Mr. Dalvi said. We have to dispel this impression that the longer the petition, the more competent is the counsel. You should be able to exhibit your grasp on the topic. You will be, the judge will be blessed if he has a counsel who has grasp over the language, grasp over the subject, and the presentation. That way, we are lucky. We are a lucky lot in the Punjab, and I'm not comparing with any other High Court, of course. We have lot many people who have brevity at their command. Drafting a large paged RSA or revision petition will not serve the purpose. This is what I personally feel. Be brief, hit the nail, and draw the attention of the bench towards that. Who else will know it better than you, Vikas?
No, sir, it's other way around. I will just give an example. Though in the lighter vein, if you remember, we had Justice J.L. Gupta out here. He said that drafting and every word is to be there. One should also check the spellings when you have drafted it, because it changes the entire gamut of the word and sentence. It's quite often used quote was that there was a case of under the Prevention of Corruption Act, and the word to be typed was that he had given bribe to the boy. So he wrote down that he had given the bride to the boy. Therefore, the judge said that once you are given a bride, he becomes your son-in-law. So the entire word bride and bribe changed. And the later way, and again, I'm reminded that when I was discussing with Justice Dalvi, and I was just trying to text in the WhatsApp, so would you like to share whether the PPT will be the part of your session? So inadvertently, it was typed as whether the PPT will be a part of the session. So the entire gamut, if I would not have checked it on the auto spell, the meaning which would have been conveyed to Mr. Dalvi would have been whether the PPT will be a part of the session or whether PPT will be a part of the session. So I was just thinking within my mind that one word here or there, one has to be very sensitive, because when I was sharing the WhatsApp with Mr. Dalvi, this point actually boiled down that right besides the pleading, one should also check the spellings, because sometimes the spellings change the entire meaning of the entire thing. So, Mr. Dalvi, what is your take on that?
Absolutely, you have to be very careful. As I said, that if you don't want to be a student all your life, and you don't want to open section 433 and 434, or for instance, I told you, I confessed that I opened order 7 and order 19 for the first time. Well, you have to pay the penalty for your lapse. So therefore, you have to be careful. You have to understand this, because you see, as I said, in section 433, 434, it is written very clearly that the notice has to go, the statutory notice, to the registered office. Nowhere says that it has to go to the head office, or it has to go to the factory. That's how it is. So therefore, you have to be very cautious. You have to be very careful. And the first thing I said was command over the language. And what Mr. Vikas said was this, that unless you have command over the language, that is a package deal. The command over the language is a part and parcel of
Absolutely.
how you draft. And it can be, it is that maybe I am biased in favor of the English language, and whatever it is. But the fact of the matter is, in fact, I tell my students, if you don't want to, I start my lectures by saying this. I mean, every law, it is not too late, it is never too late. That you see, Times of India carries a center page article called The Speaking Tree. And I tell my students to make a précis of the speaking tree every day. Now, if the newspapers have closed down because of the coronavirus, you can take the volumes which are available of the speaking tree and make précis every day. And précis doesn't mean reducing the passage to 1/3 of its size. It means culling out the sense, the meaning of the passage, and giving it out. That is very important. And that is how you can improve your English. You have to be a student all your life, your language, everything has to be that. That is how, as Lord Denning says, that language is the tool of communication of every lawyer. If that is the tool of communication of every lawyer, you have to be very good in it.
The next question would be,
what do you think about the Lendy judgments? I've already referred to it. 172 pages on an appeal from or an ad interim order application, and you see what happened. He not only was transferred, but he had to die.
Since we were just discussing, and when you said that you read the book, one of the participants had posted, which book do you recommend to learn the pleadings or drafting?
No, there are standard books. They have been from a long time on conveyancing, deeds. GM Devekar is a very good book on deeds. But on pleadings, they can't be. The present day students, they refer to what I'm horrified to say, Anajwala and Jhabwala and all these books. There are no books. They are not even guides. They are all garbage books. So therefore, what is important is that there are no pleadings books, books on pleadings. You have to be your own author of what you write.
This is a case of learning for life.
Yes, keep on learning for life. Absolutely right, Judge. You're right.
So how do you still as we all say that we are all students of law, and we often speak on this platform at least. So how can one improve? One understands that this point has to be put. So what do you say, how one should practice to put all these things in a chronological manner, and how one should improve his pleadings or drafting? What is your take? And let's assume, I was just hearing one of the webinars. It said that as a good lawyer, one should also learn the art of passive and active reading. So what is your take that how should one improve the active reading, so that out of 100 pages, he could come to the point, like there's an agreement. What is the crux point to find out the moot point? I will ask Justice Roshan Dalvi and Justice S.D. Anand also, because we as a lawyers have been burdening them with 100, 200, 300 pages petitions. Then how do They used to come to the Crux, and our 300 pages, they issue what you are saying, it should be a summary. Their judgments out of 300 pages and listening to both sides, it should used to come concise. So we will also ask them what is the theory of making it a concise and precise way to go ahead. But what is your take that one should do it?
Well, between active and passive, I am a proponent of active. I'm an activist or activism in all cases. So therefore, active voice reduces the size of the draft. Passive, when you refer to passive voice, then it goes on and on. And then you see the crux of the matter, as Lord Denning, once again, I'm referring to him, is this: the sentences have to be short. And that can't be in passive voice. Sentences have to be short. It comes very, very well in active voice.
So for an illustration, could you just explain someone what is the distinction, subtle difference between a passive writing and a active writing? I can ask ma'am also.
Yeah.
Yes, ma'am.
Well, active writing would really show that on this date, so and so happened, on that date, so and so happened, until you come to the main date, which gives you the cause of action. I don't see what passive writing can do in a pleading, really, because you can't really say that that was done. They have to give it which dates. I don't see that there is a choice. It just has to be active writing.
Right. So I think we have taken all the questions, and as usual. So, and before we part, could you just explain the subtle difference between the commercial act, between that of the Bhutan and the India? What difference did you find as such?
Between what? With India and who?
Bhutan, since sir had been.
No, I'll tell you, there is, no, in Bhutan, what happened was Bhutan did not have a constitution, written or unwritten. It's only very, very late that they had the constitution for the first time. And I must say the credit goes to lay the structure. The raw structure was laid by Mr. K.K. Venugopal, who is the Attorney General today. So he was the one who was relied upon to suggest methods, and so many others then contributed to it. What is important is this. What is important to know is this, and you'll be surprised to know, till 1992, Bhutan did not have a qualified lawyer as a judge. All the judges were non-lawyers. The first Chief Justice of Bhutan was also a non-lawyer. He was a very, very learned person. He is a learned person. He's a brilliant person. But the fact of the matter is, they first started sending people to India. Most of them came to Government Law College. And the present Chief Justice of Bhutan is my student. He was the first student in Government Law College in 1992. And you will be also happy to know that the previous Chief Justice, that is the second Chief Justice of Bhutan, is a graduate from Chandigarh. He studied in the Chandigarh Law School.
He's a 95 pass out. When I had gone to Bhutan, he told me that I'm a 95 pass out. I've passed out from Punjab University.
Yeah,
so he's 1 year junior to me.
Yeah, exactly. So he's from Chandigarh, and the present Chief Justice is from Bombay, from Government Law College. He and another student who was the minister, Home Minister in the previous government of Bhutan, they both were the first students in Government Law College. What happened was, over time, the lawyers' strength increased. It is only now that the judiciary in Bhutan has got what is called qualified lawyers as judges and also as lawyers. They did not have qualified lawyers because they didn't believe in that. They had teachers, they had various other people who were the thing. Now, that doesn't mean that they suffered all the loss. For instance, the first Chief Justice is a brilliant person. He is this. So what happened was, when they started doing this, I was the advisor to the Legal Affairs Department, which is the Attorney General's office, which is today the Attorney General's office. The Attorney General of Bhutan is also my student, and therefore they all started drafting this thing, and they did not have expertise in their own country. and therefore they engage people. And I have done, since I don't know anything about criminal law, I have not touched any criminal act in Bhutan. I have done most of the commercial thing. Now, what is important is this, that most of these laws, now for instance, we have taken everything from common law, the English law. So it all depends on who obviously um, uh, drafts the laws. And as a draftsman of the commercial laws, I must concede that I have relied heavily on Indian laws. I have not relied on American laws or any other or European laws. But basically, what is important is I kept in mind that Bhutan has got a pedigree. It has got its own grassroots, which are very, very strong. And they have got a very strong independent nationalism. So therefore, whatever has to be done, even though they had to come out into what is called the globalization, they have yet retained their old world charm. And therefore, I had to be very, very cautious while drafting their commercial laws and retain for them their ground reality and then draft their commercial laws. That care I had to take. Similarly, in the Constitution, basically what is important is, of course, for instance, take a peculiar this thing. The king has himself said that he will not be a king for more than X number of years. So that is how he abdicated his throne in favor of his son. And that is how it is. The laws are, even the constitution, of course, it has got a lot of Indian culture in it, an Indian flavor in it. And that is because Mr. Venugopal and I have contributed to it.
So this question is,
Because we were just not talking of, there was a mention of the fact that some judgment was not quoted, which ought to have been quoted. Only the other day on the YouTube we had an interview with Mr. Fali Nariman, wherein he said, the interviewer said that so and so says this, so and so says this. He says, yes, people come from different backgrounds, different cultures. But if we start doubting the credentials of the party opposite, the other part of the judicial justicing facet, we can't be practicing. I'm not suggesting that aberrations would not be there, but the number of aberrations would be very, very infrequent. I'll give you a small example. I was appearing as counsel before the apex court, and the judge heading the bench happened to be a part of Punjab Haryana High Court when I was around. There was a point which just could not have been missed by the High Court counsel here. But then the judge says, Mr. Anand, we are very sure you are not going to say that this point was raised at the time of arguments, but was not noted by the bench. Yes, my lord, I am not going to say that. So the point was well taken. There are points. And no, it has been taken care of by the CPC and CRPC. The filing of written arguments is almost mandated, in any case allowable. Do it, and in the synopsis, and otherwise don't burden the pleadings, as Mr. Dalvi very rightly said. Please educate the young lawyers in the academies. Please educate them. They are the ones who will improve the system of justicing ultimately. Educate them at your level also if the bar council will do it. And that's that.
thank you. So
Right.
we were asking a joint question. There's one question that says, what is the best way not to overemphasize or underemphasize a particular point while drafting? Ma'am can start off.
Simple facts, simplicity. For instance, as I said, in a will, you can't go. I mean, just imagine I gave you the case which has gone right up to Supreme Court. You can't say that for 84 years I suffered at the hands of my son in Calcutta. What is the use of saying page after page in that will? You can see that will is annexed. You can go to the registry and see. And what is the point of saying this? I mean, just imagine the client may tell you many things, but it is for the lawyer to have told him, get lost. Don't tell me to write what I know, what I have to write. It's very, so therefore, you see, basically what is important is all these young boys and girls who go to law firms, they must not refer to precedents. I think I expected that question from one of you all, that must you rely on precedents? My answer is no. You may read a precedent, but you cannot copy and do copy paste from a precedent. That is absolutely not acceptable.
Yes.
So, like you were saying, well, how can still one improve? That basic concept invariably comes what I talked at the first instance also. What is the best way to do that practice of improving the drafting? Reading more or reading the drafting of the other lawyers? What is your take?
Never read other lawyers' writings. Never. What is important? I'll just tell you something in a lighter vein. As I said as I began, many people may not like this, but if you read Warren Buffett, you all know that Warren Buffett is endowed with super intellect, and he has used a very peculiar term. He says it is an ovarian gift. That means meaning thereby it's a natural gift from his mother from conception to birth. So similarly, drafting is a product of your intellect. If you have it, well and good. If you don't have it, you have to cultivate. And as you rightly said, Mr. Vikas, practice. Practice makes a man perfect. And therefore, go on writing, go on making précis writing, précis of passages, editorials of newspapers, make précis, make that. And then the important thing is try to convey as much as possible in as less as possible. That should be the hallmark. You must convey the maximum in as briefly as possible. That is the hallmark of good brief draft.
So it has been a wonderful session, and especially having the insights from Ma'am Roshan Dalvi also, and with Justice S.D. Anand. As they say, it was just the right icing. I can say one could act. You had just laid down the cake, and with their coming, one had added the icing, the other had the cherry on the top of the cake. So the entire cake became good because of the combination of the three. But needless to add that as long as that base, that is what we say, if you're not drafted it properly in the civil suit, after the Supreme Court, the fate would remain the same. So you just set the tone right for the platform, and ultimately with their pinching in the right flavors and the right ingredients, that set the entire session in a good moments, which will be enjoyed by everyone.
But we got to remember, all this was said without oath.
Mr. Vikas, I would be happy, and my wife also would be happy, that if everyone, lawyer, student alike, from tomorrow stops reading precedents and start using his or her own brain power in drafting as briefly as possible. That will be the just reward, as I would say.
So I appreciate, but sometimes I can give you a flip, because somewhat little practice we also do. But once, if you maybe not use the precedents, but sometimes it has actually, I have also experienced that sometimes the client comes, you do not think on that thought process. But while you are reading that judgment, you immediately react that this could be one point. So with the reading of the judgments, one aspect definitely does come in the mind. It opens the window of the brain to think on a different perspective. So precedents, while reading the judgments, one could only gain and gauge that fact that this could give a flip to the thought process, which invariably sometimes one doesn't think so. So precedents can be cited in one particular way, but you are right, it could not be used as a platform for the purposes of laying foundation, because sometimes invariably we rely upon a judgment. And only today, while drafting some particular case, we were relying upon, for the respondents, that it is well accepted norm that judgments are not statutes. So all judgments have to be considered in each fact. Yes, one should read the judgment, but it cannot be laid as a foundation, because sometimes that particular statute or a judgment is based upon one particular fact, and one entire fact can change the entire law. Thank you. The points are well received, given by all three of you. And needless to say that all those who have joined us on the Facebook as well as this platform, I, on behalf of Beyond Law CLC, thank you all for staying connected with us. Tomorrow in our series of webinar, we have Mr. KBS Sidhu to give. He's presently the Special Chief Secretary Punjab. And those who have been following him on the Facebook, Medium, they all know that his insights on various topics is enriching in its own way. So tomorrow he will be talking upon, as we say that once a week, we try to give a talk beyond laws, because the theme is beyond law CLC. Life and leadership lessons from ancient scriptures, the way forward. He will help us to give the insights that how Gita, Ramayana, Mahabharata are to be read in the way to improve ourselves in a different way. What are the lessons which we have taken from these epics and the ancient scriptures to move forward? So do stay connected. Tomorrow at 5 p.m. Invariably, now the sessions are 4 p.m. since it's a weekend. We took a call that on weekends, invariably one tries to, though it's unlocking, but still being at home, sometimes one does feel that it's at the back of the mind, it's a weekend. So one could relax. So we thought instead of 4 p.m., let's have it on 5 p.m. So everyone stay safe, stay healthy, and thank you to the couple.
My gratitude to Mr. Dalvi, Justice Dalvi,
Yes.
and to you, of course.
Thank you so much, Justice Anand. Thank you so much. Thank you all of you. Thank you so much.
I will say in one word, thank you to the couple, Mrs. and Mr. Dalvi, for giving the insights, and you have been the backbone for helping us to move forward in these testing times. And just as SD Anand, as we always say, that the name Anand itself is good, that it gives us happiness that once he encourages us. Everyone stay safe, stay healthy. Thank you.
That is required nowadays, Anand.
So it's always required, sir. Anand movie was only hit because it's taught us to how to be happy during these any testing times.
Exactly.
Right.
God bless, sir. God bless.
Thank you so much.
Thank you.
Thank you.